Life is full of choices, be that the outfits that you pick up for the day, your shoes, your accessories. But what if I tell you, when you land up in a dispute, you also have the right to choose a person who will preside over your dispute? Yes, that's right, your arbitrator. Hello everyone, this is Sakshi and I warmly welcome you to another session of All That Is Law Arbitration series. Now, as you might have guessed, up until now, what we are trying to discuss is nothing but appointment of arbitrators under Section 11 of the Act. Now, one of the significant features of this particular provision is that it is based on the principle of party autonomy, which means that the parties to the arbitration process are free to agree on a procedure for the appointment of arbitrator. But just in case, if there's failure of the appointment of an arbitrator by the parties, then under such circumstances, although the objective of arbitration is to limit judicial intervention, but the courts can still validly intervene provided on an application of the party to facilitate smooth dispute resolution process. But again, another question that pops up in your mind is, just like I am entitled to appoint an arbitrator, but so does the other party? Yes, of course, so does the other party. But then otherwise, unilateral appointment would be just unfair, right? Now, circling back to what we have previously discussed, just in case if there's failure of the parties in appointment of an arbitrator, then what will be the circumstances? For instance, if a particular party, or for instance you, fail to appoint an arbitrator within 30 days from the receipt of request to do so from the other party, or the two appointed arbitrators by both of you fail to appoint another third arbitrator who shall act as the presiding arbitrator within 30 days of their appointment, then what is the case with the appointment? Yes, the appointment shall still be made on an application by the party, but how? By the courts or by the arbitral institution designated by the Supreme Court in case of an international commercial arbitration, or the High Court in case of an arbitration other than international commercial arbitration, as the case may be. Similar is the fashion with the appointment of the sole arbitrator. In case if the parties fail to appoint a sole arbitrator within 30 days from the receipt of request to do so from one party to another, then the same procedure applies. I hope this was helpful to you. If it was, then in such circumstances, don't forget to like, share and subscribe. Until then, keep learning, keep growing. Thank you.